Thanks for joining us. I'm Sam Raymer, and with me is Kevin Harnish. He is the head of the Investigations and Compliance Practice Group in the U.S. at Norton Rose Fulbright, and I am a partner in Norton Rose Fulbright in that same practice group and a former prosecutor. Kevin is the former branch chief of the Securities and Exchange Commission's Enforcement Division. We'd like to spend a few minutes discussing the U.S. government's view of corruption risks in Latin America and the practical implications for companies seeking to do business there. Kevin, what are your observations regarding the Biden administration's approach to addressing corruption?
Sure. And let me just say, Sam, thanks so much. It's good to be with you today and always good to talk about these important issues. And I can tell you, just to answer your question directly, the Biden administration really is taking a demonstrably more expansive approach to combating corruption. And maybe it would help if I gave a few concrete examples to essentially drive the point home, so to speak. And I would start with late 2020. And the US Congress enacted a new anti-money laundering law here in the US. And there are a couple important components to that. First, this new law has expanded whistleblower rewards and protections for reporting AML concerns to the US government. What that means is they're actually bounties, they're monetary rewards for people who come forward to report to the government suspected AML problems. So that's going to lead presumably to a large uptick in leads for the government here in the US to be following up on. And then from an investigative standpoint, this new AML Act has really expanded the ability for the Department of Justice to compel the production of documents from non-US banks that have a correspondent account in the US, which, let's be honest, most do. And here's the important part of that. Those documents that they can seek, they're no longer limited to just that correspondent account. So that opens up a whole new universe of information for the DOJ to really get their hands on and analyze. And this is it's a really aggressive position that's being taken with this legislation. Those powers, they haven't yet been tested in court. I'm sure they will be. But for now, the DOJ is in the process of trying to use this new authority that they have. Then if you fast forward just a few months into June, the Biden administration followed up by issuing a memo designating corruption and money laundering as a quote unquote core national security interest. And in that memo, just by way of background, they estimated that up to 2 to 5% of global domestic product is actually stolen by corruption. And so they're really wanting to try to put an end to that, certainly significantly reduce it. And this new strategy, it involves bringing together the resources of, count them, 15 separate federal agencies, not just the Department of Justice, but it's really the entire national intelligence community. And all of those agencies under this directive have been ordered to work with their international partners to battle corruption. And then at about the same time, also in June, the Biden administration established an anti-corruption task force focused specifically on combating corruption in the Northern Triangle. And part of the mission of that task force is to train local law enforcement in those countries so they can better conduct their own corruption and AML investigations.
Very, very interesting stuff, Kevin. It's a good time also to remind everyone that with that June 3rd executive order, the Biden administration tasks all of those 15 agencies that you mentioned with an executive review of their anti-money laundering capabilities. And they gave those agencies 200 days to come up with their recommendations. And the 200 days is up on December the 20th. So as scary as these new developments might be, there are definitely some others coming down the pike. So Kevin, what do you think this all means in practical terms for those seeking to do business in Latin America?
Yeah, look, that's a great question. And I think from a practical perspective, that there are a few takeaways, but something very important is really looking at how the US prosecutors, how they form close and cooperative working relationships with their local counterparts throughout Latin America. And you're seeing the fruits of these efforts from a prosecutorial standpoint. This has led to several large multi-country resolutions with prominent companies in South America. Just a few that come to mind. We've got Sargent Marine, J&F Investimentos, and Vital, all of which are in Brazil. WPP, they recently reached an FCPA resolution involving issues in both Brazil and Peru. World Acceptance Corp did the same thing with respect to its issues arising from its subsidiary in Mexico. There's been the ongoing FIFA related matters that involve many defendants throughout various parts of Latin America. Those are just a few examples that are top of mind. I would also add, Sam, that based on recent statements from various US agencies, and including the recent directives you and I have just been talking about over these last few minutes, the focus on rooting out corruption and money laundering in Latin America, it's only going to become more intense.
I completely agree, Kevin. And so the two of us, we've been in the prosecutor's chair many times. I was a general counsel. You were of a corporation. You were a branch chief, actually directing prosecutors. So what should companies be doing to account for these risks going forward, based on what you've seen, based on what we've seen at Norton Rose?
Absolutely. And it's important to focus on these things. And as I think about it, Sam, as we've talked about these issues, I really have three concrete suggestions that are worth thinking about. First, if the work you're doing has a US connection, you should carefully assess the DOJ's expectations of what constitutes an effective compliance program and do a gap analysis. It's something we often help companies do. Well, basically, what's your program like compared to the expectations? And that offers significant protection, both against having a problem in the first place. That's obviously the goal. That's the gold standard. Or in the case of a rogue actor, it helps maximize the chances of convincing the DOJ that there's no reason to be prosecuting the company, or to at least be lenient in what they're doing. Second, thoughtful and robust due diligence on M&A targets and joint venture partners. It's absolutely critical. Of course, everybody knows you want to try to avoid buying into an unknown problem. However, you also need to assume that when you want to exercise an exit strategy, your counterparties are going to be doing their own due diligence, or you've got to presume they're going to be. So not doing your own due diligence up front not only exposes you to unconsidered legal risks, but it really can hamper your exit strategy if it turns out that you're sitting on a problem. And third, and I really cannot emphasize the importance of this enough, and that is doing post-close diligence and compliance integration. We all recognize that oftentimes you're not able to have access to everything you might want when you're doing your pre-deal diligence, but that changes after closing. So you really would be well served to do a deeper dive on corruption issues post-closing, and that includes integrating your compliance framework into the new entities or operations. Look, we know it's all too common for companies to put off doing this in the midst of the myriad of other things that require attention after closing, right? Everything seems important, but putting off this post-close diligence and compliance integration, it's a recipe for a problem. And we've seen that happen time and time again. So we find ourselves doing an increasing amount of compliance and diligence work for clients after closing. Remember, as we like to say, closing is not the end of a transaction, but in many ways, it's just the beginning.
Oh, those are excellent points, Kevin. I'd also like to remind everyone that Lisa Monaco, the Deputy Attorney General of the Department of Justice, in October made a statement that they're going to be looking to target individuals who are committing all kinds of corruption and fraud and money laundering, and focus on really going after them hard. And these new tools are going to help them achieve that goal. So not only is it easier for them to do their job, but it's also never been more dangerous. And so I really appreciate, Kevin, you joining us today. And thank you for those insights on these important issues. And thank you all the listeners for their time today.
Thanks, everybody.